My name is Ronald Nyanga. I'm a solicitor, and today I will be talking on the recent changes on immigration, which came into effect on the 11th of November. As most of you would know, that there's been a lot of, since the white paper reforms proposals at the beginning of the year, the UK government has been slowly trickling in different changes and rolling them out on bits by bits, no doubt causing huge implications to different migrants whom this affect. These are the raft of the reforms that have been proposed at the beginning of the year, and the impact of the changes are being felt now, with the most recent one, which was announced, which came into effect on the 11th of November, which is just sometimes the beginning of this week. For those who joined us for the first time, please make sure you subscribe so that you can be kept updated on any future changes that we have. I want to just briefly mention them and go into expound a little bit so that people are quite kept up to date with them. But before I start, just for the purpose of housekeeping, today's purpose is purely for information only. It's in no way to be considered as legal advice, as legal advice should be taken on your own circumstances with a qualified legal professional. If any matters that I will be talking about concern you in any way, please feel free to arrange a one-to-one bespoke guidance. But this is just for information only, and it's not to be taken as legal advice. It's just a disclaimer I just want to put forward there. Yeah. Just to start on some of the changes that have come into effect from this week. The Home Office has actually rolled these ones, and of course, they will no doubt have an impact on any pending applications or any applications that will be applied from that date forward. One of the things that has come into effect is the new expanded grounds of refusal. The Home Office will have from the 11th of November wider grounds for refusal of applications while processing the applications. You may wonder why this is important, but in actual sense it is, because in the past, under Part 9, there were specific grounds that were quite narrow that Home Office could refuse. But now, with the new changes, many applicants will find that when they're making applications, the chances are that if they fall foul to any of those areas, it is more likely than not that an application will be refused. And I'll just give you some of the areas that have been affected by this new change. One is in a circumstance where there has been deception, as an example. Whenever people used to make applications, sometimes there will be an element of deception, and on balance, sometimes the way that the Home Office used to deal with may not have been as stringent. But now, with the new changes, the threshold of how it is considered has been lowered. The proof of the threshold proof has been lowered. So what this means is that the Home Office no longer need to prove that a deception, as an example, has taken place on balance of probability, which was the case. Previously, they had to be satisfied that on balance of probability, deception concerns have been committed. With the new changes, the position is that the Home Office just need to be satisfied. As long as they're satisfied that one has committed an act of deception in any application, that will be sufficient grounds for refusal. That is quite a big significant shift from what was there before, where they had to be on balance probability that has a deception occurred, yes or no, and that had to be weighed. That is the first major change that has occurred on expanded grounds of refusal. So with that means that one needs to be careful when making applications, because if it is considered at any point in time that deception has occurred, then it is more likely than not that a refusal will follow. The other aspect that has also been together with these grounds of expanded grounds of refusal is on the immigration breaches. Um, Again, this has also been expanded. Some areas which were previously not considered as part of the immigration breaches. Now, the remit of that has been expanded to include aspects of overstaying. That means that anybody who has overstayed, that will now be considered instantly as a breach of immigration rules. Any illegal entrant as well, that will also fall clearly within the mandatory refusal of the new and under the realms of the expanded grounds, and also any prior deception. What this means that even if there was an element of prior deception before, but subsequently one proceeded to get granted a leave, now that will now be considered, because any prior deception, as long as it had been justified at the time, and perhaps you may have been granted leave, unfortunately, now this may be taken into account. It is just worthy for you to bear that in mind. The next next point, which I want to mention also, is on the removal of previous exemptions. And this comes into effect that previously there were some exemptions where could be applied in certain applications. And for instance, when someone had been an overstayer, there were exceptions when we were dealing with paragraph 39E. Now, that were particularly when it was to deal with family or private life applications. They could usually benefit from that paragraph 39E, which previously allowed late applications within 14 days of a visa expiry if there was a good reason. Now we will see that with the new changes, the approach is going to be quite different and more stringent. We find that under paragraph 39, now with no change, paragraph 39 is now going to be absorbed into what's known as the SU 13.1 of past suitability. Essentially, what it means is that applications are now going to be considered in a much more narrower and more rigid fashion, meaning that most applications which are caught by that, any aspect of overstaying may be considered to be under strict mandatory refusal. So that is something which has changed extensively. Before there were exemptions, those benefits will now not be there, and that just means that when an application is being made, it has to be fashioned very carefully, bearing all these changes in mind. Another very, very important change that has occurred with effect from 11th of November is the criminal conviction leniency. Before, the Home Office were quite lenient in how any criminal convictions could be considered. Um, Especially when it comes to things like Appendix FM, which is family applications, custodial sentences of 12 months to 4 months could normally be disregarded after 10 years. So, there was a window which that granted that kind of leniency. However, now with the new change, this carve out has been removed, and it means that any criminal conviction resulting in a custodial sentence or imprisonment of 12 months or more now automatically triggers mandatory refusal under the UK immigration rules, and that's regardless of how long ago that may be. As I said before, there was a limit up to 10 years, and after that, it could be disregarded. So it's quite clear that there's been a fundamental shift in how this approach will be taken. And criminal convictions, again, the mandate of that has also been expanded, and it will include things like violent offenses, sexual offenses, drug trafficking, any fraud or financial crimes, theft or burglary, and of course, more importantly now, to bear in mind, driving offenses, especially where one may have caused death by dangerous driving. So that's quite a new approach to things, which wasn't the case. So it's mindful that one bears that in mind if you were considering applying for leave at some point. Just bear in mind that the approach on the criminal conviction leniency, which previously existed, has now been narrowed extensively. Now, the other approach as well, which the other issue which I want to mention as well is the route specific flexibility. Previously, family and private life routes members had also a much more softer suitability test when it comes to application, whereby there was a lot of discretion that could be allowed in cases which involve children or perhaps even a long residence. Those flexibilities, tended to enable, family people applicants on FM or private life to benefit from some element of discretion which the Home Office had, and there was some flexibility there. Now, the new route subjects all applications to a uniform approach, focusing on conduct and character test, which means that elements of re-entry bans, deception, anything of that sort will now be considered and will trigger mandatory refusal. So the leniency that was there has been drastically reduced. The other aspect as well, which has changed, is on safeguarding discretion. Safeguarding discretion, again, previously we saw that the Home Office makers tended to have some discretion when it came to applying matters of the family. The decision makers had wide discretion when assessing those applications, especially where issues and concerns of safeguarding may have been raised. Now, with these new changes, which have been effective from this week, 11th of November, under SUI 6.1, now the Home Office or entry clearance, they must be refused. Those kind of application must be refused if the applicant's parent or their partner is considered to pose what's considered as a safeguarding risk to a child. So you can see how elements of safeguarding now comes out very strongly. When applications are being made, unlike before where there was some discretion in those kind of issues. We also see that when it comes to human rights, this is another area where there has been a lot of a fundamental shift in the approach, how they're dealt with. Human rights override is now narrowed. Previously, it was possible to see that human rights claims under Article 8, particularly under the ECHR, which could usually override suitability grounds more easily. They could usually sort of turn a blind eye in some cases to make it possible for applications which were human rights related or private life. Now, the position has changed, unfortunately. And such overrides, which previously granted benefits to applicants, will now only be possible where refusal would be considered to be unjustifiably harsh. I mean, that is a higher threshold test which has been made, and consequences are that a much higher threshold has emerged from this, which means that more applications, unless you can be able to demonstrate that there would be unjustifiably harsh consequences on that application, then more likely than not, such applications will be refused. Now, the other aspect of change, which I also want to mention, is it is quite evident that with the changes, the Home Office now has got an increased discretion, which I mentioned before, especially with things like safeguarding, which I mentioned earlier. And to mention what kind of things which will trigger this, this has now been reduced in terms of the benefits to the applicants, but the Home Office has got a wider discretion in how they decide, and of course, you know how they're going to decide if they have discretion, most likely to your detriment, especially if in applications where it can be considered that the applicant's parent or a partner may pose a significant risk to a child, essentially welfare issues. And a few examples include if at any moment in time concerns have been made or complaints have been made, which may trigger automatic refusal, include things like where there is a known history of a child abuse or neglect by a parent or a partner of the applicant. Again, that now will be a critical point. And we know many times, many people fall foul of this. There could be issues of child abuse or neglect in any sort. As long as there's been a complaint, which has been lodged, which the police or the social services, that will now become a critical part. Issues of domestic violence as well. All these are part of safeguarding concerns, which now the Home Office will have wider discretion on. Issues of domestic violence, again, where they involve a parent or a partner, especially again if children are exposed to that. So it's important that applicants who have children just make sure that the children are not exposed to any domestic violence anyway, because now this will become critical to any applications. If they go and report to school, there's an element of domestic violence at home. It may trigger safeguarding concerns, and ultimately that will have an impact now on applications. Also, elements of sexual offenses. Again, now that also falls under the safeguarding aspect. Against, especially against minors, even if not directly to the applicant. It doesn't matter who that sexual offense is to, as long as the applicant now applying for leave, this will become issues of consideration. And also substance abuse or mental health concern, anything which can be considered to impair the parenting ability. Those now will become quite important in the consideration of whether or not one should be granted leave. As I mentioned earlier, any reports to the police, social services, indicating, especially if it can be said that risks to to a child's welfare may be impugned, I think that is something which will have a negative impact on application. And lastly, there any court orders restricting contact in cases of family disputes, where if there's a court order restricting contact with a child due to safeguarding concerns, again, now that will become a major factor in how an application will be decided. And as I said, with the Home Office's increased discretion, they're more likely to decline an application which carries any of those safeguarding concerns. Now, those are some of the changes which occurred. Now, in addition to that, we had some good news for students, which has been impacted by these new changes. Students seems to be the beneficiary of this new change. It is a big win for them because students can now convert or transition directly to innovative founder visa, and which enables them to establish a business immediately upon conclusion of their studies. Gives them tremendous advantage, and of course the aim of this is to encourage entrepreneurship. And you may be wondering what has changed. What has changed is one, there is now what's classed as direct transition from student visa status to innovative founder visa. Before that, students had to leave the country and reapply with a separate endorsement. Now it will be much easier for international students who can now proceed, immediately to switch directly from the student status to the innovative founder visa, without having to leave the UK, which is quite advantageous and of course saves them money, provided that they will have a valid endorsement for an innovative, viable, and scalable business. So that's quite good for them. And another very positive news on that aspect of students, as well as we know, is previously there was a hindrance, as a financial hindrance, because there was a requirement of £50,000 investment which was required. This requirement has now been removed. It's quite helpful. £50,000 used to be quite a lot for somebody who's just graduating. It was beyond many people's reach. This requirement has now been removed, and applicants who previously had to show 500,000, so £50,000 investment don't have to do that anymore. Instead, they must purely demonstrate evidence of sufficient lawful funds, and funds have to be lawfully obtained, which includes a solid business plan, something that's innovative, a game-changing idea, something that's viable, scalable, business plan to be able to be assessed by the correct endorsing body, to show that this is a viable business, and that would be quite helpful. And the benefits of this, if you go to other routes like skilled workers, self-sponsorship, for example, it's 4 5 years, subject to going to 10 years, depending on what the Home Office will decide. Under the Innovative Founder Visa, it is within 3 years. Stay up to 3 years, and you'll be able to apply for indefinite leave to remain. Of course, that is subject to Home Office changes, but at present, that is the position. Again, they can bring dependents, which is quite helpful. We know the skilled worker who don't care; they can't do that anymore. And again, the pathway leads to settlement after 3 years, which is quite a shorter time as opposed to the other one, which is 5. I would say it's a very good route for entrepreneurs who are fresh from university and want to consider how they can be able to settle in the UK. Now, the other thing that I need to just to mention as well, which has been impacted by the change, is the human rights compatibility. Again, the change, as I said, has limited the discretion on human rights application. As I said, where safeguarding risks have been identified, refusal is now going to be mandatory unless there is an overriding human rights issue under Article 8 apply, and with consequences which can only be deemed to be unjustifiably harsh, as I mentioned earlier. And I just want to add that although this discretion has been limited, but where safeguarding issues have been raised and triggers a mandatory refusal, it is still possible to argue that actions would breach Article 8 and actions would be unjustifiably harsh. So it provides a little bit of an opportunity there, as long as you can establish that the actions would render what would be deemed as unjustifiably harsh, then it is still possible to argue this, but obviously one would have to prove it. Now, with all this, with the changes, one critical thing that I want to mention is the transition element. Normally, we always know that laws are never retrospective; they apply moving forward from that point. The interesting thing about this particular changes of 11th of November is there is no transition period. All applications, including those which were submitted before the 11th of November, so it doesn't really matter whether one had submitted one before the date that it became effective, which I know before that, the people were encouraged to make applications to make sure they beat the deadline. Unfortunately, this is not going to be the case, irrespective of when you made your application, provided that a decision has not been made. They will now be assessed under the new rules, and they'll be set in accordance with the rules effective from 11th of November onwards. This is quite harsh, I understand, and I quite agree. But unfortunately, this is the new rules which have come to play, and of course, we are all have to abide by them. So that just gives a rough summary of the relevant areas that have changed, effective this week. So you can see big win for students. Some changes on family and the Part 9 grounds, which have now been replaced by the Part Suitability, limiting certain areas, introduces areas like the safeguarding aspects, so it just makes it more even important for people to be aware, elements of history of child abuse and neglect. Those people have to be careful about that. Domestic violence, as I mentioned, sexual offenses, substance abuse and mental health issues, because it could be deemed to be impair your ability to parent, police issues, social services, and any court orders concerning contact. All those factors now, we more than ever, we need to be more careful about them. And as I said earlier, the expanded grounds of refusal, as I'm summarizing, people to bear in mind about deception. Now it's going to be considered, so long as the office is satisfied that this occurred, more than just balance of probability, which was the case before. So the threshold is much, much lower for them to be able to establish that there's been deception, and of course with overstaying. So that just gives a round summary of what happened. If anybody has any questions about this, obviously you can always reach out later. But I'll take a couple of questions here, on the panel. I can see people have asked. If anybody has got any questions, please post them there. But that just gives you a round summary of the topics of some of the changes that came into effect this week on the 11th. I hope that helps. I'm happy to take a couple of questions, and I'll just look at the chat. If you have any questions, please type it on the chat and see whether we can deal with them. Right, I've got a question here from Babatunde. You're asking, can a dependent switch to innovative visa, or can someone on graduate route switch to? Yeah, a dependent can switch to any route. And provided they have an idea or a business proposal that's going to be, innovative, scalable, in the context required, there is there's nothing to prevent them from doing that. If there's a dependent who wants to do that, it is quite possible, provided they meet the requirement. Or can someone on graduate route? Yes, of course, someone on graduate route can also switch to that particular route. I hope that helps you, Babatunde, in that. If you need any more guidance, you can always reach out privately, and I'll be able to talk to you in that. Thank you very much, Paul. I can see you there. Paul Wambugu, thank you for joining us. Right, so I've endeavored to cover the in summary of the changes which came into effect on the 11th of November. I accept most of them will be quite impactful to people's lives, but I think we hold these sessions to create awareness, so that even as you go along your lives, you're able to know how to navigate. Be careful. You can see how driving offenses, a driving ban will now have an impact. Safeguarding issues will now have an impact. Criminal convictions will now have an impact. And things which were not as important before, but this is a scenario we find ourselves in. So as I conclude, unless there's any other question here, again, you can just type in the chat. If any of those topics relate to anybody and they want to have a one-to-one discussion, I'll be more than happy to highlight them. If it's your first time joining us here, please make sure you subscribe. I post regularly on this channel, and of course we'll be notified if there's any more information. I've been running series on the self-sponsorship on different business ideas which are helpful. If you look at my YouTube channel, there are various topics. I think we posted up to series 5. We'll be doing the next one next week, and which just gives you different ideas on what business one can form under the sales sponsorship. But today was just to bring you up to speed with the changes on how they impact. As I said before, they apply immediately. There is not retrospective effect, so there's no transition period, as in most changes which we normally have. So even if an application is pending that has not been decided, you're minded to know that the new rules will apply. Jean Casera, Ronald, we can't see your face. Are you able to see me? Somebody's saying they can't see my face. I'm not sure if that's correct. Right, but Jean has confirmed I can see. So Jean, everybody else can see me, but good to see you, Jean, and thank you for joining us here. Everybody else seems to be able to see me other than yourself. So maybe your camera, just need to adjust something on your camera. But I hope you are able to follow Jean, even though you can see. I hope you're able to follow on some of the updates. Yeah, thank you, Angela, for confirming. I think everyone can see me other than yourself, so it could be your camera. Now, somebody was asking, can you work full time? Sorry, can you work full time on an innovator visa? Yes, of course you can. That is going to be a full time role. If you can do that, and of course, you're not restricted. You can work full time. Somebody's asking as well, why are they changing so many things like this? Do they want immigrants never to get ILI? I mean, that's a question which I really can't answer. But I think you may have been following the news, the drift of the discussions from the political parties. You know, the Labour seems to want to be at par with the Conservatives, and of course, at par with the rhetoric from reforms. It's some of it is politics, but this is the reality of where we live in now. So many changes. Somebody's asking for the innovator visa with the 50,000 for someone who is applying from abroad and has just finished school also be waived. There is no longer £50,000 requirement. That used to be the position. So I think Asiku Roy, right? I think that's your question. Previously, one was required to have £50,000 investment. That is no longer there. So irrespective of where you're applying from, it's no longer a requirement for innovative founder visa. Faith, thank you very much. Good to see you. And again, Angela, as a kind of main applicant on skilled worker visa switch to innovative visa. Yes, it is possible to switch. As long as you have a valid visa, you can switch into any of the point-based system. And yeah, you can do that. There's nothing to prevent a skilled worker visa to switch to that, provided that you can get endorsement and from the four main bodies. Let's see if there's any other question before we wrap up. But I think I've answered all the questions. If anybody has any aspects or any questions that they wish to discuss, please feel free to reach out on a one-on-one basis. I would be happy to talk you through. Thank you very much for those who have joined us today, and I hope the information is helpful. Please follow and subscribe so that we can keep you posted. And once again, have a wonderful weekend, and thank you very much for your support. Unless there's any other question, somebody asking, can you work full-time on an innovator visa in another firm while starting? Can you work full-time on an innovator visa in another firm while starting up your own business? Now, of course, this is going to be your business, so you have to, the rules will still apply on the 20 hours rule. This is going to be your main business. You may work here, but the restriction will apply. If you want to know more details about this Asiko Roy, you can get in touch, and I'll be happy to assist you further. Ladies and gentlemen, thank you very much all for joining and for subscribing. Those who haven't, please do. I'll be posting more updates as they come. Next week we'll be posting on the series 6 on the various issues, topics and ideas that one can use. And that, thank you all very, very much for joining tonight, and I wish you all a very good week ahead, and thank you for supporting us. Thank you.